Thanks, Kate. The key recommendations of the Harper review that came out recently, there's a few headline issues, but I think the ones that are going to catch most of the attention and focus are the proposed reforms to Section 46 of the Competition and Consumer Act and the changes which are being proposed to the secondary boycott provisions in the Australian consumer law. Now, on the first point, the Section 46 changes, at the moment Section 46 applies what's called a purpose test. That is, a company that has a substantial degree of market power that's found to have misused that power for the purpose of acting anti-competitively. What the Harper Review panel is proposing is to change that purpose test, or to keep it, but to shift the focus so that in addition to a purpose test, there's also what's called an effects test, and that is, will the conduct in question have a substantial effect on competition in the market? And that's the recommendation that's got everybody up in arms. Coles and Woolworths are most unhappy with the recommended change. The business groups are split. The Business Council of Australia thinks that the recommendations are no good, whereas the Australian Chamber of Commerce and Industry thinks that the recommendation strikes the right balance. So it's very difficult to know where the recommendation will go if it passes into law. What it is going to do is bring the court and the ACCC very much into the forefront of determining whether conduct has a substantial effect on competition, and if it does, are there any pro-competitive aspects to it which will mean that it doesn't breach the particular section. What I think is a very interesting second recommendation, which hasn't received as much media attention, is the proposal in the report to increase the penalties for secondary boycotts. Now, secondary boycotts are practices engaged in by trade unions which involve essentially the prevention or hindering of supply to organisations with whom the union is having an industrial dispute. At the moment, the secondary boycott provisions carry with them a penalty of $750,000 as a maximum. The committee has recommended that the penalties be increased to $10 million, and they've also recommended that the ACCC pursue the secondary boycott provisions with more vigour. There's an implied criticism that the ACCC perhaps hasn't been as vigorous in pursuing secondary boycott conduct as it has with some of the other competitive conduct. A related aspect to that, another recommendation that's going to put them on a collision course with unions, is the proposal to subject enterprise bargain agreements to a competition test. At the moment, unions are able to negotiate enterprise bargain agreements which impose restrictions on employers from using labour hire companies on the number of independent contractors they can use. One of the recommendations says, well, you should subject that to a competition test, and you should give the ACCC leave to intervene in Fair Work Commission proceedings to say whether or not that's anti-competitive.
So, Brett, what's next after the report?
Well, it's a 500-page report, Kate, with over 56 recommendations. There's a lot for the federal government to chew on. The responsible minister, Bruce Bolton, has said that the government will now consider the report, consult with key stakeholders, and come up with its views in about 10 to 12 weeks' time. So we're probably looking at the next financial year before we see what the government's position is. After that, well, we all know that the difficulties the government has in getting legislation through the current Senate. So I think that the idea of competition reform is worthwhile. It's a good idea because it's 20 years since we've had a substantial reform program. However, the politics of this are going to be very interesting indeed.
Well, Brett, thanks for talking us through some of the key recommendations.
Thanks, Kate.